The chief technology officer of Ripple, David Schwartz, has spoken about the company's plans to join together with major firms like Medico and SSBC in the crypto custody industry, which is expected to be worth $10 trillion. He made the comment when appearing on an episode of the Thinking Crypto podcast not long ago. In particular, the discussion illuminated Ripple's purchase of Medico, a custody-focused company. The presenter brought up the story from last year regarding Ripple's collaboration with international banking behemoth HSBC and its eventual purchase of Medico. He wanted to know whether these changes were going to be detailed and if HSBC will use the XRP ledger in its business processing. In response, Schwartz said that Ripple's goal of being a one-stop shop for institutional adoption of cryptocurrencies necessitated a thorough solution, which is why the company decided to investigate the custody scene. The significance of providing a platform that allows users to access the XRP ledger, tokenize their assets, and make payments was emphasized by him. A secure custody solution, he said, was an integral part of this plan. A provider that offers custody, liquidity services, payment solutions, and access to on-ramps and off-ramps should be the first stop for institutions seeking to enter the crypto market, according to Schwartz. With a projected valuation of $10 trillion by 2030, Schwartz further highlighted the importance of the custody business. If tokenization continues to rise, Schwartz predicts that the custody is a massive market that will be worth around $10 trillion by 2030. In addition, he emphasized the critical importance of a trustworthy custody arrangement when institutions take the lead. Whether they are stablecoins or central bank digital currencies, he claims that safe storage is going to be critical. In discussing the partnership with HSBC, Ripple's chief technology officer brought attention to the fact that HSBC is planning to launch a client-specific custody solution for digital assets. He likens this strategy to a layered service in which HSBC employs cutting-edge technology for custody. What makes this agreement stand out is that HSBC is taking on client compliance as its own obligation. Regarding the security status of its XRP sales, Ripple has achieved substantial victories against the U.S. Securities and Exchange Commission. However, some questions remain unanswered in this conflict. The continuing dispute over the institutional sales of XRP has garnered a disproportionate amount of attention from experts. It is expected that a decision will be taken on the same by April 2024. New information regarding the Ripple lawsuit has emerged as the company and the U.S. Securities and Exchange Commission have been arguing over who has access to financial records and how to identify XRP sales. A court order compelling Ripple to comply has been sought by the Securities and Exchange Commission. For the years 2022 and 23, this includes audited financial reports, details about XRP sales, contracts for selling or transferring XRP to non-employees, and any funds received following the commencement of litigation. Ripple has stated its disagreement with the SEC's demand for audited financial records, data on the money from institutional sales, contracts linked to XRP sales following the lawsuit, and other information in the most recent update regarding the SEC's complaint against Ripple Labs. Ripple filed its objection on January 19. The SEC finally responded in favor of its plea on Tuesday, January 23rd, after a considerable amount of time had passed. In its request for information regarding remedies, the Securities and Exchange Commission maintains that it is both appropriate and timely. According to the document, courts usually consider the facts after the complaint has been filed when dealing with violations of securities law. Both the IT industry and the cryptocurrency market are poised to be profoundly affected by the SEC's toughened stance against Ripple. How Ripple responds to this law's potential verdict may set a precedent for how other cryptocurrency companies are investigated and regulated by U.S. securities laws. The introduction of a spot Bitcoin ETF has caused some shifts in the XRP. Rumors around the potential for a subsequent spot XRP started spreading earlier this month. According to previous rumors, the asset management firm BlackRock was looking into this option, but the company has since denied that it has any plans to go in this direction anytime soon. Market analysts have expressed skepticism about the likelihood of the approval of a spot XRP exchange traded fund amidst the ongoing fight between Ripple and the SEC. According to experts, the approval of a spot XRP spot ETF is highly unlikely due to Ripple's ongoing legal battle with the U.S. Securities and Exchange Commission and the fact that XRP Futures does not have an approved exchange-traded fund. Unless the SEC is obligated to admit or concur that XRP is not a security, it would be difficult to obtain clearance for an exchange-traded fund that invests in XRP, according to Townsend Lansing, head of product at CoinShares. How will the case involving Ripple and the attractive developer play out? The vast historical history of the Ripple versus SEC battle makes it difficult to make an informed prediction regarding the result of the litigation. However, experts in the field and those who study the market are predicting that the Ripple case will be settled around the middle of 2024. The case of Ripple might be significantly impacted by the SEC's ongoing legal dispute with Coinbase, according to crypto law expert John Detton. According to Detton, if Coinbase's claim is well argued and successfully concluded, a settlement in the Ripple litigation may be possible. Coinbase asked the Securities and Exchange Commission to drop the accusations against them. This action, which took place in October, questioned the SEC's authority to oversee the cryptocurrency market and the legitimacy of crypto sets listed on public exchanges as investment contracts. Among the many cryptocurrency companies, Ripple Act Supply is one that is under intense legal attention from the SEC faction. The Securities and Exchange Commission has recently filed a reply in support of its motion to compel, further strengthening its case against Ripple in this ongoing drama. Gathering crucial financial data and responding to specific Ripple inquiries are the goals of this legal strategy. The audited financial reports of the business for the previous 2 years, in particular details on institutional sales contracts entered into after the complaint, have been the main targets of this approach. Recent steps made by the SEC show the agency's determination to continue investigating and finding a solution to this matter. Earlier in the proceedings, XRP was classified as a security involving institutional sales due to the regulatory body's partial victory. This ruling signifies that the governing authority has reached a verdict. Notwithstanding this, the CC is determined to continue pressing Ripple for complete transparency. The SEC's strict stance on Bitcoin business compliance with regulations is evident here. The cryptocurrency market is now on hold as the court hands down its final ruling about the reparations that the blockchain startup must pay for its XRP sales to institutions. In the long-running legal battle against the U.S. Securities and Exchange Commission, Ripple has recently won multiple major victories. On July 13, 2023, Judge Annalisa Torres delivered a landmark decision stating that no XRP token retail transactions met the criteria for securities sales. But she did say that sales to institutions were eligible. Now it's up to the two parties to try to settle on how much money Ripple should pay in damages. Have a peek. Embark on a journey with us as we showcase the revolutionary impact of cryptocurrency's email afternoon newsletter. In this case, the Securities and Exchange Commission asked Ripple to provide financial statements covering 2022-2023, along with its post-complaint contracts governing institutional sales. On January 11th, Ripple asked for more time until January 19th, but by the given deadline, Ripple's legal team had filed a response arguing against the request. This response requested that the court reject the government agency's request on the grounds that it was both unreasonable and issued at an inappropriate time. The SEC has responded to Ripple's arguments in a new court filing, stating that Ripple's opposition to the request for audited financial statements and the presentation of contracts linked to XRP sales has been defeated by the Securities and Exchange Commissions. That's all for now.